Hello, good morning, welcome back to this channel. Today I wanted to share with you some basic thoughts on linguistic plurality, on how a democratic and pluralistic state, for instance Spain, which is my country, with its 1978 constitution that enshrines the idea of protecting diversity, of promoting pluralism as a core value of our system, how a country like Spain, a pluralistic and democratic country, should deal with the idea of linguistic plurality. Every country has linguistic plurality because every country has a lot of people that live within the country, that are citizens of the country, that uses different languages. It's the case, for instance, of migrants, of expats, which is the name we gave to rich migrants. But normally, expat or migrant communities are not big enough to consider that public administration, public powers, have an obligation to offer them services, to offer them the possibility to interact with them using their own languages. We respect and we protect their decision to use their language on their daily life, but that's all. That's all for the moment, because maybe in the future, if these communities grew up and they begin to be big enough, we will have the obligation, and it will be logical to offer them the possibility to interact with public administration using those languages. It would be costly, but it would be fair. But for the moment, the problem in some countries, like Spain, is that we have not those communities, but traditional communities, which are big enough that use other language, a different language, than the official language for the whole state. In Spain, the case is with Galician, with Euskera, and with Catalan, which is the biggest of those communities, because Catalan or Valencian, which we can also use this name for the language. Valencian language, Catalan language, is shared by more or less a third of the population of Catalonia, the Balearic Islands, and the Valencian country, País Valencià, which is the eastern part of the country of Spain. We all live, because I come from Valencia, by the Mediterranean Sea. We are speaking about 5 million people, which is a big community, that may be native speakers of those languages. Our mother language is Catalan or Valencian. We speak that on daily basis. So, well, there are big reasons to protect that. Therefore, we have at least two issues. The first one is how to protect the rights of those citizens, and the second one is whether or not public administrations have the obligations to foster the use and to protect this heritage. Regarding the first issue, we have to say that the Spanish constitutions protect the speakers of those languages, and we have created a legal framework that is, well, enough in order to do it in procedures that has been formalized before public administration. Section 3 of our constitution says that the Spanish, Castilian, which is the official name, is the official language of Spain, but also that there are other official languages in those regions, if and when the regional constitution of those regions establishes that, which has been the case. In those cases, Section 15 of our administrative procedure law established that every citizen, if we live in those regions, we have the right to choose using Spanish or the other official language for any interaction, any formal interaction with public administration. That more or less solves the problem. And, well, that's okay. The problem is that this is a right only when we are dealing with administrative bureaucracies established in those regions. For instance, you don't have the right when you have to deal with an administrative bureaucracy or an administrative procedure that is based in Madrid, and sometimes that's the case, that you need to do it. There's also a problem with judicial procedures in which those rights are not so well established. In theory, they are if you are acting before a court which is established in those regions, but in practice, there's a lot of problems. And of course, we have also the problem when you go before a court which is located in Madrid. But the other problem is that informal interactions are not protected, are not covered. I understand why, because it's complicated to organize that. But that may lead to different problems. For instance, you don't have the right to interact with a police officer in those languages, which has created some problems. The other problem related with informal activities is that public administration does not only interact with citizens in formalized administrative procedures. Public administrations, they make a lot of things. They offer information, they interact in very different ways. And also they establish a framework of an institutional framework which may be created in Spanish or in the other language. In order to promote and to protect those languages which are endangered, as you know, because, well, they are little by little being displaced by Spanish, which is the case of other minority languages in Europe, public administration in those regions of Spain have traditionally tried to establish some regulations saying that, well, the informal interaction of public administrations in those cases should try to be made in those languages, or that the name of the things or institutions, or, for instance, that the first interaction with a citizen, before you know which language the citizen wants to use or is using, should be made in the minority language. That is the case, for instance, at the University of Valencia, where I work, and it's interesting that a recent decision by a judge has said that this is not allowed. That informal communications within the University of Valencia should be made in Spanish, or at least also in Spanish, but is not allowed under this decision of the judge to do it only in Valencian Catalan. That's crazy, because in order to be part of the staff of the University of Valencia, you have to know Valencian Catalan, so everyone knows Valencian Catalan, which is logical, because we have to teach in Catalan or Valencian, or we have to offer to our students this possibility to interact with us in formalized procedures, bureaucratic procedures, using Catalan or Valencian. And it's crazy, because for 30 years we have had this regulation, and it has created no problems at all. But our course, the Spanish course, tend to be very critical of those ways of promotion. I hope this decision is going to be reversed at the Supreme Court, because there is case law from the 90s of the last century saying so, also case law of our Constitutional Court, but especially because this second question, whether or not public administration should foster and promote those languages, has been solved by our Constitution. Section 3.3 of our Constitution established that Spanish, Castilian, is not only the official language of Spain, and that we have the possibility of having other regional languages with this official status, but also that these official languages that are not Spanish are part of the richness of Spain as a country, and should be promoted, protected. If that's not enough, Spain is part of the European Charter for Regional or Minority Languages, which is a European convention for the protection and promotion of languages used by traditional minorities. It's an international treaty that establishes specific obligations which Spain should abide to. Because we are not dealing with recommendations, we are dealing with international obligations that are on a higher level even than our Constitution. But in this case, there's no problem at all with that, because this convention is coherent with the idea of promotion in our Constitution. The interesting thing, and that's my latest thought, is that Spain, when Spain joined this charter at the beginning of the 21st century, we were late adopters of the charter. Spain decided to, because the charter offers the possibility for each country that is part of the charter to choose the level of obligations in order to protect languages that they want to comply with. And Spain chose the highest possible level. So, according to our own decision, we are forced, because we have an international treaty that says so, to offer the highest level of protection, which means not only to offer the right of citizens to interact in the language they prefer to, but also the obligation of promote and protect languages in all those different levels: education, justice, and administrative activities. We are not doing that. And this case law, this recent case law of some tribunals in Catalonia and Valencia, should be reversed by the Supreme Court, because we are not acting accordingly to our institutional, international, and constitutional obligations. What do you think on that? I would be glad if you make me some comments, or if you have questions, please write on them in the comments, and I will try to ask them. Bye bye.